We'll just go ahead and get started with counsel for appellant, please.
Good morning. My name is Bailey Lowther, and I'm the attorney for Somali Ang.
I am Casey Bushelon. I'm the attorney for Bun Tao.
Okay. All right. Anyone? I don't see anyone else on my screen. Okay. I'm just going to start this morning by providing a little bit of the procedural background that tells us what led us here today. Ms. Lowther, it's my understanding that you filed your notice of appeal on behalf of your client in January of 2025. After you did that, our court notified the parties that the case was being pre-screened for our appellate mediation program. That order that we issued in February of 2025 required both sides to complete and file several mediation forms with the court. Both parties did that. And on March 6, 2025, our court entered an order of referral to mediation. That order of referral to mediation also required appellant to file a response within 10 days. Appellant did not do that, though, and we had to enter a follow-up order requiring appellant to file its response within 5 days. Ms. Lowther, it looks like your client did that and complied on March 26, 2025. And the parties notified the court that they had jointly selected Mr. Stephen Chase to serve as the mediator in this case. On March 31st, our court appointed Mr. Chase as the mediator, and that meant that the parties then had 60 days to complete their mediation. But on June 10th, 2025, Mr. Chase filed his required mediation report and informed us that, quote, despite several efforts, the mediation could not be scheduled, and it is the mediator's understanding that the parties have not filed a motion to extend the deadline. So then on July 1st, 2025, our court entered an order to show cause, ordering appellant to file a status report within 10 days, setting forth the date and time selected by the parties to mediate the case, and requesting that the court extend the time to complete the mediation accordingly. In addition, we ordered appellant to show cause in writing why sanctions should not be imposed against both the appellant and appellant's counsel, Ms. Lowther, personally, for the failure to comply with the order referring the case to mediation. My understanding is that as of today's date, we still have not received any response to that order to show cause. Because we did not timely receive a response on July 22nd, 2025, this court set the show cause order for hearing, which we are here for today. And we also ordered appellant and its counsel, Ms. Lowther, to file a notice within 5 days indicating that you received the order setting today's show cause hearing. But it's also my understanding, Ms. Lowther, that no notice was ever filed with us. At least I didn't see one as of this morning. So I think what I would like to start by asking you, Ms. Lowther, is if you could please provide us with some background and what's going on your end that has led to your failure to comply with several orders entered by our court.
Thank you, Your Honor. Everything you have said, I believe, is absolutely correct. My initial delay in complying with scheduling the mediation was the result of difficulty communicating with my client, who was in Cambodia, where she is from. And so I was simply unable to reach her. When I did finally reach her, she did confirm that, she was available and willing and able to move forward with, the appeal and the mediation. But I was then unable to contact her for a significant period of time, again, interfering with the scheduling. That being said, all of the fault here lies with me, not my client. My client is originally from Cambodia. Her English is not good. When I speak with her, her brother-in-law acts as our translator. But, I have to confess that I do sometimes find myself uncertain as to exactly what she does and does not understand. Uh, So, I would simply say that all of the fault is mine. I failed to comply. I have no, real excuse for it. Any difficulty communicating with my client is my responsibility. And certainly I should have notified either, Mr. Bouchon and Mr. Chase and or the court, of that situation. And it was completely my fault that I didn't do so. So I would simply ask that any sanctions be directed to me as opposed to my client.
Ms. Souther, when I understand that it's difficult to communicate with your client, but I'm curious as to why, when we've asked, when we sent a show cause order, why did you never file anything with us telling us that you were having trouble communicating with her? She's out of the country. Maybe there's some uncertainty. Why wasn't there anything just filed on your end saying, here's what's going on?
Your Honor, to be perfectly honest, I don't know. I have no good excuse. This is the first time in my career that I have ever acted in this way, that I've ever failed to comply with a court order or missed a deadline. I could give you a litany of, you know, personal and professional stressors, but I don't think any of those excuse my conduct. I really have no excuse.
Okay, but you did receive the various orders. Did you receive the initial order to show cause
I did.
requiring? Okay, did you calendar that? It gave you 10 days to file a response in writing.
I did. I again, I really had no good response. As I said, I absolutely should have communicated with, all other counsel, and the mediator and the court as to the status and what was happening, and I failed to do so.
So, ma'am, are you telling me that you're receiving our orders, you're calendaring the deadlines, and then just disregarding them? Is there an alert system telling you when you have something due or an assistant who helps you with that?
I, to be clear, Your Honor, I, I was not unaware of the deadline. I did not forget about it. I simply did not know how to respond.
I see. So you were concerned about like the content of what your response to the order would have been.
Correct.
Okay. And then what about, let's see, on July 22nd is when we set this show cause order for hearing. And all you had to file with us was a notice, right, in 5 days indicating that you had received it so that we know to assemble the team, to make sure we have all the judges on the line, to get our IT people in place so that we don't come online unnecessarily. We want to know, in addition to other things, we want to know that you all will appear for the hearing and that will not all be for nothing. Why didn't you file a notice just indicating to us that you had received the order setting the show cause hearing?
To be perfectly clear, I think when I saw it, I was so horrified by it that I failed to read it through completely and simply calendared it and overlooked the requirement to file a notice.
Okay. Did you inform your client about all of this going on with all of the show cause hearings and that you had to appear today?
When I last spoke with my client, when I last was had contact with her was at the end of July, and I did inform her of the status at that time.
All right. Um, Chief Judge Traver, do you have any questions?
I do. Thank you, Judge Brownlee. What have you done since that time that you spoke with your client about getting the mediation set?
I'm sorry, Your Honor, I couldn't hear you.
What have you done since the time that you last spoke to your client, or since when you just said that you spoke to your client at the end of July? We're now sitting here in the middle of August. What have you done to get the mediation set?
I have not been able to do anything as I have not been able to contact her to confirm her availability.
I mean, you're under a court order to set a mediation. What have you done to try to do that?
Well, Your Honor, I have been trying to, I have reached out to my client and asked her to contact me with her availability for the mediation.
How often have you tried that in the last 6 weeks?
I would say approximately once a week, maybe twice a week.
Um, We're in a situation where, say, your client got back to you today, your opposing counsel has his schedule and his clients, you have your schedule, the mediator has his schedule. Let's assume that you can get this mediation set by the end of September, which is 6 weeks from now. That basically means by your admitted conduct and inaction, we're looking at least a 4-month delay in this particular case. Because mediation was supposed to be completed by the end of May. What do you think is an appropriate sanction against you for delaying an appellate case for 4 months with no good reason or explanation for it?
I have thought about that, Your Honor, and I don't know. Certainly, I think that I should be responsible for any costs, incurred. Beyond that, I simply am not sure. I have considered it. I just don't know.
I mean, this isn't something that any of us at this court enjoy doing. The whole point of the mediation program is not to inject unnecessary adversarial conduct into a proceeding. And yet here we are after a show cause order where you've admittedly failed to respond to 3 different of our orders. And it's taken Judge Wozniak and Judge Brownlee and your colleague away from other things that all of us could be doing over the course of that particular time. I say that as a minor point. My last question for you involves, I guess, a degree of concern on my point that if you are not able to respond to multiple court orders from the 6th District Court of Appeal, I have some concern as it relates to your office setup and your ability to respond timely to your clients in your other cases. I wonder if that's best left as an observation, or if I asked you a more general question of what is the sort of help that you are getting in your office? Are you a solo practitioner? Do you have an assistant? What type of calendaring system do you have to make sure that you are fulfilling all of your obligations to your clients and to trial courts and appellate courts throughout the state?
Absolutely, Your Honor. First, I assure you, this has been certainly not a one-time event in this case, in that I've had multiple infractions, but this case has been unique in my experience. I've never had any other difficulties meeting any deadlines in any other cases. I am a solo practitioner. I do have a part-time assistant who helps me on an as-needed basis. For example, right now I'm preparing for a trial beginning Monday. And so, she has been in my office this past week, helping me with documents, getting everything ready. My calendaring system, I primarily rely on a paper calendar. That's simply what I prefer. But I also do use Outlook, which I have synced up to where when I receive, various hearing notices of deadlines, they are saved in my Outlook calendar, so they appear there as well.
Judge Brownlee, I don't have any more questions.
Thank you, Chief. Judge Wozniak?
I have one question. I'm looking at your Florida bar profile, and I see that you graduated from law school in 2001. So if that's accurate, you're not a new attorney, correct?
Correct.
Okay, but you were admitted to the Florida bar in 2017, is that right?
Yes.
Okay, so what are you admitted in any other jurisdictions?
I am admitted in Texas. I am inactive simply because I've never practiced there. I was planning to, but never did. And then prior to Florida, I practiced in Louisiana up until 2010, which is when my husband and I moved to Sarasota. And then from 2010 to 2017, I was not practicing. We have 4 children, so I was at home with them. And then I took the Florida bar in 2017.
And there have been no issues like this, any show cause proceedings, sanctions, reports to the bars, anything like that in any of these other jurisdictions?
No, not in Texas or Louisiana. In Florida, in the interest of full disclosure, I have had 2 bar complaints. One was filed by the plaintiff in a case in which I represented the defendants. And that was found to be, completely unfounded. The second was filed, and I apologize because I cannot remember the approximate time frame. I think it was about 2020. The second was filed by a couple who had consulted with me while I was at my prior firm about representing them in a case that had been filed against them in Massachusetts. And at that time, I advised them that I am not licensed in Massachusetts. And, I told them that they would need to get an attorney there. Uh, and then subsequently, I guess, for whatever reason, weren't entirely clear on that. And they did end up having a judgment entered against them. They never did hire a Massachusetts attorney and had a judgment entered against them in small claims court in Massachusetts and filed a bar complaint against me alleging that I had, told them that I would represent them in that case. And I received a private reprimand, and took a ethics class.
Okay, those are my only questions.
Thank you.
Ma'am, what's your primary area of the law that you practice?
I do a good bit of insurance litigation, typically representing property insurance, not personal injury. A lot of hurricane type claims, storm damage. I do construction defect work, and then I also do commercial litigation as a whole, I would say, but primarily, I would say about 80% of my practice is construction defect or Johnson v. Davis type claims, and then also property insurance claims.
Have you ever handled an appeal from inception to like from notice of appeal to mandate,
Not in Florida, no.
but you have in other states?
I believe, yes, in Louisiana, and that would have been back in, I believe, 2005 or 2006, and I cannot recall if I handled it from start to finish. And also at the time, I was with a firm, so I would not have been handling it by myself.
Okay. I guess one thing I'm concerned about, ma'am, to be frank, is, when we leave here today, whatever goes on ultimately with the mediation in this case, if you continue to represent your client, your client continues to wish to pursue the appeal in this matter, there's going to be several orders that come down the pike. You're going to have deadlines where there's going to be motions for extension of time, perhaps, for example. There's going to be orders. I guess I'm very concerned that of your ability to comply with the orders that we enter in this case as it proceeds. And I'm wondering, are you also concerned about that?
As hard as this may be to believe, I am not concerned about that. As I said, the failure on my part over the past few months to respond to this court's orders has been unique in my experience. I am quite confident that going forward, I will not have any difficulty complying with the court orders.
You feel capable with your current calendaring system of representing someone before our court?
Absolutely.
Judges, anything further from anyone? Okay. And counsel for appellee, sir, is there anything that you need to bring to our attention at this moment?
No, Your Honor.
Okay, thank you. All right, we will take this under advisement and issue an order. Everyone have a nice day.
Thank you, Your Honor.